structural background, but I'm awfully aware, as I trust we're all aware, that this is a multidisciplinary organisation across many disciplines of engineering, but also from the legal fraternity, being forensic engineering. So we always try to, with any of our topics, so we're on the committee, we organise for speakers to present. We're always emphasising to all of them to have that breadth of appeal across multiple engineering disciplines and also across the legal fraternity as well. Amongst other things, some of you have been coming for a number of years will know that we've had a number of, we've had lawyers, we've had barristers speaking to us. We've got a return gig in December this year. Sorry to do more plugs, but there's lots of things coming up. We've actually got in December, we've got a recently retired federal court judge coming to speak to us in December, who's been here a number of years ago as well. And he likes engineering things, so he's really keen to come back. And he wanted the December meeting because he knows it'll be in party mode. So I think that'll be a really fun night. So we work really hard to intermingle the engineering and the legal fraternities and disciplines, and that's really, really important, which is what is involved in forensic engineering. Okay, so for tonight, it's been 18 months since I've actually spoken at FESA. I used to do it every year when I've had a bit of a break, but it's always been about something that's collapsed. That's the things we like to have. They're always great photos, great drawings to put them on the board, but not so tonight. And I was really struggling. I thought, oh, it's going to be a lot of text up there. But what I make up for, what I lose from not having lots of really nice photos to talk about and sort of describe, and usually they're in other countries, it's actually a very local issue, a very near to us all issue tonight. And it's certainly got applicability across all engineering disciplines here in Victoria. So I will cover examples from the building and structural side of things, but very much I've got in mind that even though I mention the examples, I'm always hoping you're thinking of where might this apply to me in my particular engineering discipline. So particularly sort of certification. So that's a bit, okay, great. So I'll just talk through each of the slides. There's a lot of words up there. I've broken the rule of not having more than 20 words on a slide, but I'll just take my time and walk through. So for those that remember, we had Bronwyn Weir speaking to us here in this venue last June. That's her second time that she's been here. And I also shed some light on this in my bulletin in November last year. She spoke about a number of things that are going on to do with the rollout of various registration schemes and also changes in the building industry, which follow on from the Building Confidence Report, that pivotal report that she co-authored with Peter Shergold a number of years ago, which is working its way through all of building regulation in all jurisdictions across Australia. So she gave us a bit of an update about that last year. And also, just an aside, she's doing our she's doing our Zoom presentation on the 29th of this month. So this is our pub. We alternate between pub, Zoom. So the next FESA night's a Zoom night, 29th, and Bronwyn is actually speaking at that night. She always draws a full house when it's in person, so I think that'll be a great night as well. So Patrick is organising that one as well, so you can look forward to that. But one of the things that Bronwyn mentioned in that presentation last June, amongst other things, when she was commenting on particularly her close working relationship with the New South Wales Building Commission, and particularly the now retired Building Commissioner David Chandler. She's done a number of reports for them, was just that there's been particular attention given to engineers in the industry, in the New South Wales industry that they've been focusing on, who've underperformed and there have been problems with. And one of the things that Bronwyn mentioned that night, you may remember if you were here, but she made reference to the Australian Consumer Law, which has, you may have done it out of interest, you may have done it out of sort of a policy requirement within your own organisation to be familiar with Australian Consumer Law, the old Trade Practices Act, about the do's and don'ts of what you can and can't do in commerce and trade and all the rest of it as we run our businesses. But there are these broad-ranging things called consumer guarantees for products and consumer guarantees in relation to services that are being provided. And when she looked down she said she hadn't realised this until recent times, that the consumer guarantees re services, so I've actually listed the three main headings there. So consumers have a guarantee that the providers of services will exercise due care and skill, that what they do is fit for a particular purpose, and that the service is provided within a reasonable time. The consumer has a guarantee under law that these obligations apply to the service provider. However, engineers and architects are exempt. from that fit for a particular purpose one. And she said how she was a genuine new thing she hadn't realised. She got a real surprise. I was surprised that night. If anyone else was here that night, you probably heard the gasp in the room to find that by law, engineers and architects are exempt from the consumer guarantees that it's got to be fit for a particular purpose. And she was not happy about that. I wasn't happy about that. I had a little bit of to and fro with Engineers Australia about that afterwards and dug around about some of the information. And they're fully on board with that. They actually support and actually lobby to maintain that exemption, which, yes, I can see a few quizzical faces around the room. So I didn't like it. But anyway, it was as a result of that which actually planted the seed for what I'm talking about tonight. Okay, so again, FESA to the rescue. Really interesting point is raised. Something gets stuck in your brain and you've got to do something about it. So that's the start of where all this came from tonight. And Consult Australia on board as well. So just a little bit more about Bronwyn's work. So the previous time she spoke to us was in February 23. And this was for another particular project which he'd been engaged by the New South Wales Building Commissioner. It was David Chandler then. She spoke here that night about this house with no piers, about just a domestic dwelling that was built up on the New South Wales North Coast. And it was just a total nightmare. All the service providers, the builder, the engineer, everyone was involved. The lawyers who got involved afterwards, there was just a litany of errors right through, and Bronwyn spoke very well about the whole thing. And it was really David Chandler. So the New South Wales Building Commissioner personally got involved with this one particular incident to try and find some redress, to try and find some remedy for these poor consumers of this house who had been dudded by everybody in the whole process. And this was the report that he engaged Bronwyn Weir and her firm, so Weir Consulting. And this is the report they wrote, House with No Piers. If you get onto the New South Wales Building Commission website, it's there, you can access this. It is an excellent read. It is a jaw-dropping read, some of the parts you see about the colossal failures, particularly from engineers and particularly from lawyers as well. And I remember Bronwyn saying that night, she held her head in shame, but actually it didn't do any favours for the legal profession at all. So, so that was an excellent night we had that night. But also, that sort of planted the seed, certainly with the New South Wales Building Commissioner, that he was less than happy, not only with the performance of individual engineers, but also, because he actually engaged with Engineers Australia as a result of this, very disappointed with their response as following up the performance of individual engineering members. So he had a real thing in his, being his bonnet about this. And so one of the things that actually came from this, and this is back to June last year, which is the update that Bronwyn gave us here. She was talking about the number of reforms. So New South Wales, in the building industry, I can tell you, New South Wales has gone from being the joke of Australia to actually being the ones that are leading the pack as far as standards and actually raising the bar for what the industry is supposed to be doing. It has been an enormous turnaround through the actions of people like David Chandler, but also the Building Commission goes on, and also engaging excellent professionals like Bronwyn in the work that she's done for them as well. And one of the things that actually resulted from that in New South Wales, one of the reforms, was this practice standard for professional engineers that New South Wales government had actually put out. Engineers Australia opposed this because it actually went into areas that previously we'd had exemptions from under the ACL, Australian Consumer Law. But Engineers Australia, I think, picked the wrong fight to upset a guy like David Chandler. So he pushed this through. It's actually an excellent document of what you should expect from engineering performance and actually how they should conduct themselves and engage within the industry. Focused on the building and construction industry, but just the principles involved that flow from that applied across all disciplines. I'm not going to go through all the fine print of it, but just the point is that there has been change out there. I can remember decades ago when I worked in a consulting engineering firm, the way things had been is the way things are always going to be for consulting engineers. You just do your best, no one can touch you. If something goes wrong, well, they always chase the builder or something like this. There was never any comeback. Well, there's a lot of change going on with this at the moment. And the precedents that are being set in New South Wales, combined with the other issue I'm going to be talking about tonight, is the registration system that we've had emerging out of Queensland, which has been operating for almost a century now, since the early 30s. You've had professional engineers registered in Queensland. That's all sort of coming together now to produce what we're dealing with here in Victoria, and it's going to be rolling out across other jurisdictions as well. So, one, you have to be informed if you're going to engage with this, but I think it's really, really encouraging. So it actually raises the profile of engineers and it raises the value of what we do. I've worked for engineers and in consulting firms that would always undervalue, couldn't sell the value of what we do, the benefit that we provide, the risk that we take to clients. But it's because of the bar is being raised. That means that what engineers do and what they charge and the risk they bear and the expertise that they bring is actually worth the money that you charge people. So it's actually a good thing that way as well. So before we get further into the detail, what I want to talk more about, a couple of things. So, old adage, little knowledge can be a dangerous thing, and beware the bush lawyer. So I know this is Forensic Engineering Society. We mix legal and engineering, and we all find it interesting. I particularly find it interesting, but I know which camp I'm in, and I know I'm not a practicing lawyer. So that little quote there, well, it's actually a quote of mine. That's actually what I put at the end of the much larger paper that I've written, which is relating to this topic tonight. I'm actually presenting a paper at the Biennial Concrete Conference in Adelaide in September. So I'm writing about this whole topic tonight, plus a few more things. And right at the end of it, I've just put this thing there to just say, I'm not a legal practitioner. So again, if this plants any seeds or makes you think about a few things, again, don't be surprised. I certainly won't know the answers to everything for all the questions tonight. But some of these things really do get into the weeds as far as our engagement and our interaction with the legal fraternity and the legal landscape of how we operate. And you need to get the appropriate input and advice from that. So this is the name of the actual paper that I'm putting on. So it's the NCC, it's the National Construction Code. That is the nationwide building regulation. So it's a nationally agreed set of technical standards. But building regulation is essentially done by the states in Australia. So each state agrees to append the NCC to their own building regulations. That's the way it works. Every state's got its own building regs, but everyone takes on board the NCC. So the NCC and other building regulations, ignore it at your peril if you're a structural concrete engineer, because that's the target audience I've got in Adelaide. So I'm just doing a sort of shaved down version of that tonight. So again, forensic engineering or not. So I actually don't do any forensic engineering in my day-to-day job. Very interested in it. It's made a huge difference to how I do my engineering, how I think. So I don't actually do the forensic engineering, but we're all playing in a legal landscape, and I'll be moving into other things to do with the legalities, the regulatory landscape that we all have to operate in. We may not know that we are, but we are. So we can't be ignorant of these things, so we need to be well informed and to respond to that. Okay, so just some definitions of things I'm going to be talking about tonight, not because I've made these up, but this is how the regulatory landscape itself defines things. When we talk about compliance, and I used all those C words in the promo for this, I had compliance, conformance, and certification, and a few others. When they talk about compliance, and often we find these terms used interchangeably. We often see these words just mixed up all together in the same engineering speak. But compliance, strictly speaking, means you are complying with regulation. Okay, so you comply with regulations. When we're talking about conformance, so it's all about comparing things. So a design needs to comply with regulation. In the building game, designs need to comply with the NCC. So the requirements in the National Construction Code, which is meant to guide designers, not just a guide as in, this is a good idea and it'd be really good if you could think of these things. You must satisfy these things. You must comply. That's the design. And then what gets built, it has to comply with regulation as well. So it covers both. And it's actually a separate exercise to check the two of them, to see that they comply with the regulations. That is the law of the land. Then we use the word conformance. Conformance is used, and you can find this information through, the Australian Building Codes Board, the ABCB, which is the one that actually writes and manages the National Construction Code. They define all these terms. Conformance is when we're actually just doing a comparison between design and construction. So that's a really important thing. So what somebody designs, especially if it's an approved design, it's important that that gets built. And you don't know if it gets built unless someone checks it, inspects it, and does the comparison between the two. So conformance is between design and construction. Compliance is about holding them up to the law. Then we move into contracts. And we all would have done Contracts 101 as undergrads. Even those of us that don't work in the legal profession, we all have done that. So remember, one of the essential requirements of a contract, it has to have a lawful object. Okay, so after all the other things you've got to have an offer and acceptance, exchange of consideration, you've got to have capacity, and you have to have a lawful object. You can't have a contract for an unlawful object. Okay, so we've got to make sure that whatever the contract is about, it's got to be something that's actually supported at law, which is what the last point is going to be. But I'm just going to raise a few things first about contracts. So we can have a number of combinations of things here. We could have compliance of a design. So the design complies to the regulations. We could have what's constructed complying to the regulations. It doesn't mean they have to actually hit an exact level in the regulations. You can always do better than what's in the regulations. It's a minimum. But you could have non-conformance between the two. One might be overdone than the other, but they still might get over that minimum bar that the regulation requires. So you can have compliance and non-conformance. Switching it around, you can have conformance, so the design and the construction match each other very well, but they don't comply. Now, contractually, if they conform, then that's actually an easy street for if you're running a contract. And usually construction contracts are about ensuring that actually what's been designed gets built, you get paid and everyone goes off happy days. But if you've got issues where there's the design or the construction separately to what might be written in the contract might not comply with the regulations, even though the contract itself might not directly pick that up, you could well have a problem, which could cause enormous issues commercially, for the whole project, legally, in all sorts of areas. And the bottom line from that, of course, is that you can't have a contract which tries to contract or work its way out of, or just ignore or say you don't have to comply with your obligations. So again, an example from my game, but from your other disciplines, you might think of ways that this might sort of be reflected as well. Quite typically in my game, so I'm in the concrete construction field, a number of us are here tonight. We've just been locked our friends out here. Sorry, there we go, trying to get in. Very good. Very good, that was lucky. So you talk, I'll speak over you. Carry on, that's very good. So, so quite commonly with the sort of industry that I'm involved in, the most common thing you see people saying is whatever is designed and built has to comply with AS 3600. That is the concrete structure standard. We see it all the time. That's what we're used to. And so it gets to the point where you'll actually see that within a contract. That's what you have to do. That's what people think, that's all they have to do. But when it comes to buildings, so there are all sorts of structures we can build. But when it comes to buildings, which are structures which are governed by the Building Act, the building regulations, which are essentially structures in which people have to occupy for residential, for working, for leisure. This building is actually covered by the NCC. We're not talking about bridges. We're not talking about roads. We're not talking about other types of civil engineering structures. Oh, need to find a seat somewhere. So whether a contract to do with concrete construction refers to the NCC or not, particularly if it does not refer to the NCC, you're not let off the hook without having to comply with the NCC. It is the law of the land. And I think, certainly I think a lot of the engineers in my game that I come across, they tend to believe, that's what they've been told, that's what everyone around them tends to say to them, is that as long as you comply with AS 3600, you've discharged all your duties in relation to structural concrete design in the field of buildings. And I've got some examples showing a bit later on about that. In fact, we'll move on to that straight away. What I've got here, now look, don't get worried about all the fine print. Oh, you might be able to see it if that's okay. What I've just taken here is just a snapshot of two of the standard forms. Those of you who get involved in building certification here in Victoria will recognise these. But in other disciplines where you have to certify anything to some regulatory standard, there'll be something like this. All the other states have got a similar set of documents like this. It may apply in other engineering disciplines as well. But the one on the left, that's a certificate of compliance for proposed building work. That's design. So this is the Regulation 126. Regulation 126 So that's the design certification. This is certificate of compliance for building work. That's construction. So this is to certify something about the design that's been prepared in relation to a building. And this is having been inspected, that you're certifying what's actually been built. Okay, Reg 26, so Reg 126. So a lot of people have seen these things. But when you look at what's actually got to be filled in here, particularly about here, what you're actually referring to, on the left side of both of them, what's the act or the regulation or part of the NCC that you're actually certifying compliance with? Nothing there about what Australian standard you've actually worked to. Again, nothing there about what the client's expectations were. And there's a case I'm going to be looking at shortly in which the engineer ended up being, losing the appeal. They actually appealed to the idea of actually, well, I was just giving the client what they wanted. That doesn't count. This is a certification that your design work or the inspection you've done of someone else's construction work, that this has complied, so it's a regulatory thing, complies with something within the regulatory space. And certainly when it gets into the technical details of things, you won't get anything out of the Act, a little bit out of the regulation, but the NCC, within the building game, the NCC is the one. And no point putting in references there to AS 3600 if you're doing concrete structures, or AS 4100 for steel. No point putting in Australian standards references there. They want NCC references there. So you need to know about it. And and I'll talk more about this at the end, if you've engaging with, or perhaps even falling foul of the new registration system we have for engineers, professional engineers here in Victoria, you may well have found that you're expected to have a working understanding and knowledge of how to apply the National Construction Code. And if you haven't played in that space before, that might come as a bit of a rude shock. So I'll talk more about that a bit later. So really important thing though. So again, look, I'm sure lots of people fill these things in, you fill them in, you sign it, you give it to the building surveyor, it's stuck in a file, the job goes ahead, everybody moves in and things move on. But if anything goes belly up and they have to go through and audit the whole process, these sorts of things will definitely get picked up. So, and the cases I'm going to be talking about later on is actually because of defective certifications. It hinged on the fact that there was a defective certification issued by an engineer, like these forms here, which turned the whole case, which actually got the engineers in big trouble. Previously, they wouldn't have got in trouble because they would have thought they would have got out of the exemption from consumer guarantees. But there's another part within the Australian consumer law that actually picks this up. So again, it's a certificate of compliance. Compliance is about to regulation. So if you see the word compliance, don't start thinking about Australian standard. Yes. Well, ask it and I'll see what I can do with it now. Or
it remains on pretty much the active regulations. There's a huge load of acts and regulations in there that are really
Good, fine. I'm not actually going to get into the weeds of the NCC or the Act or the regs, but other than to say that this form here itself is actually out of the regulations. So again, you can't just be armed with the National Construction Code, so if you're in the building game, and just go off and do your own thing. You have to engage with the with the building regulations. So this is the Victorian case. Queensland's got its own. New South Wales. Every state has got their own building regulation, and you have to engage with their process. Yes, there are as well. Okay, so it's a big topic. So I'm definitely not thinking I'm going to cope with everything tonight. So very good. So right, so back to the Australian Consumer Law, or its formal name is the Competition and Consumer Act 2010, which is the old Trade Practices Act 1974. So this opens up this next part of it, which is going to lead into some of these cases I'm going to look at tonight. So there's a section there, Section 18, which deals with misleading and deceptive conduct. And this is in relation, pardon me, and this is going to be in relation to these particular projects, and engineers are involved and how they fell foul of this. And also just to let you know that it's not only about, so obviously, especially in legislation, words are important, the actual words have meaning and it's really important. So not only misleading and deceptive conduct, but as it says there, as was amended in 1977, conduct which is likely to mislead or deceive. So that's part of it. And so these particular two cases here, so what is commonly called Mistrina versus Australian Consulting Engineers, New South Wales Court of Appeal. So Supreme Court, Court of Appeal, High Court. This is really getting to the top of the ladder of what you can do legally in Australia. And then Actron versus DEQ Consulting, Queensland Court of Appeal. So these are cases that have both actually gone very, very high up the rung. Mistrina, they actually applied to take it to the High Court afterwards, and that was refused. So that is actually law now in New South Wales. And I would also just mention that because it is to do with the Australian consumer law, it's Commonwealth legislation, so these precedents apply nationally. The building regulations vary from state to state, but the ACL is Commonwealth legislation, so these precedents speak everywhere. Okay? So I'm going to get into the topics now of these particular two cases. And again, as I've harped on about a few times tonight, this is forensic engineering now. We are talking about engineers that have actually had their work and their conduct that's actually been hauled up in court. And one of the things that is really important that we should all take advantage of is that because it is forensic, it's in court, it's public. You can find this information out. You don't have to know someone on the inside. You don't have to get a private copy from somewhere else. If you search around for the right keywords, you can actually find these. And it's very important to read. These particular cases, so the actual judgments themselves, you can find these. The Mistrina one, that's 29 pages, 18 pages for the Actron one. Can be a bit of a hard read, wading through it. But what happens with significant cases like this, you find a lot of legal firms, once these judgments come out, they'll actually put one of the lawyers, one of the partners in the firm, they'll just write a little bit of a 1 or 2 page summary of it. Very easy to take in. So the one on the left from a mob called Burke, I don't know who Burke lawyers are. It's all freely available on the web. And so someone there has just done a little write-up of what the Mistrina case was about. And then the one on the right, that's, as I said, senior legal counsel at FESA Group. They're a big construction firm. So in-house construction lawyer, he wrote a bit of a blurb about the Actron case, and that was posted on LinkedIn. I think I found that, it just sort of came up. So lots of this information is very well out there to find. Much easier to read like this than going back to a judgment, but you can get to the parent judgments themselves, which add in all the facts and give you exactly what the reasons for the consideration of the judge involved is. So I just encourage you. So those are the references. So NSWCA 223 in 2020. If you type that into Google, you'll actually find information about the Mistrina case. If you put in QLDCA or Queensland Court of Appeal 127, 2018, you'll actually find the information. You'll find the judgments as well. And it was only having seen Bronwyn's presentation in June last year and then thinking, oh, this sounds really odd about how the ACL works. That's what actually got me interested in this. As a result of that, I find this information, presenting to you tonight, doing another conference later on this year. Really important stuff. So you can go away and find all this information easily yourselves. Rightio, so lots of words. I'm sure you're going to read through it. I'll just talk through it. And then depending on how we go with all the food coming out, I might take a break after this one and then finish it off after that. So Mistrina. The consulting engineers involved who got into strife over this, that's Australian Consulting Engineers. The director there is the one who's primarily in trouble, a guy called Dr. Anthony Hasham in Sydney. And so the bottom line for this was that ACE issued a defective certification, like one of those ones we saw for Victoria before, but it would have been the equivalent in New South Wales. And they certified that the design complied with the NCC, but it emerged that there was evidence, uncontested evidence, that it didn't. So as a result of their defective certification, all this sort of flowed out. So what have we got? So Mistrina was the developer. ACE had a contract with the design and construct builder, Jabcorp. So you'll note that ACE did not have a contract with the developer. That's another thing which the people relied on in the past. Oh, they didn't have a contract with me, so if I've got something wrong, another party can't sue me. Well, that's not what happened here. So someone outside the actual contractual arrangement between the engineer and the builder, the developer themselves actually pursued them. And of course, this is at the Court of Appeal. So it went through the Supreme Court. There was a judgment that they weren't happy with, so they took it on further. So Mistrina is the appellant, and of course ACE is the respondent in this. So at the lower court, just at the Supreme Court level, at the trial, they found in favour of ACE. And Mistrina wasn't happy with that, so they took it up to the Court of Appeal. Okay, so what was it? It was in Brighton Les Sands, around the bay in Sydney. 10-storey mixed-use building, which was designed on a raft slab. So for those who don't play in the space we do, so a raft slab is just like a great big slab on ground. You make it beefy enough and stiff enough so it'll support the structure you put on top of it, so that it won't flex or sink into the ground, and so you essentially support your loads that way, a raft slab, not piles drilled into the ground, not sort of other systems, just a really, really big slab. Much smaller version of that is what a lot of people build their houses on these days, what we call raft slabs, just a big concrete slab all over the ground, and it just supports all the loads within itself. That's how it works. Okay, this is back in 2009. So, almost finished with 8 stories completed. With 8 stories completed, the design certification, of course, would have been done before this. The design certification would have been done before they started construction, okay? But with 8 stories completed, a neighbour complained that there was damage on their property, the adjoining property. Unfortunately for Ace, the neighbour happened to be a structural engineer who knew his way around the NCC and other things, and he could show that this new development that Mistrina were doing, that its construction actually damaged his property that he was in. So he was in some other multi-storey development. And if you're familiar with the NCC, you'll notice that one of the requirements is that what you build must not cause damage to adjoining property, to neighbouring properties. Okay, so he complained. There was the damage that he could verify from the evidence that there was damage to the adjoining property. The design was defective, and that was it. Even at the initial trial, there was no dispute, no objection that this actually constituted misleading and deceptive conduct by the certifying engineers. That was never in dispute. The reason it went through the first trial and onto the Court of Appeal was actually looking at the agreement or the legal definition of what's the extent of actually who's responsible for what and who's going to be paying for this. Okay, so what happened was they found this at this late stage. So the complaint was lodged in April 2010. That's when they became aware of it. The lender for the development was Bankwest. They were due to get repayment in 4 months later for the development being completed. Once this thing happened, everything stopped for a year or more to argue over it, to then design rectification works, to do the rectification works. The lender had enough. They weren't going to wait. They weren't going to go beyond that. There are other complications, of course, with this. Anyway, they called in the loan facility, and that stopped the job completely. So Mistrina, the developer, they were forced to sell the incomplete building once the rectification works had been designed and built. And also, they had to sell the family home because the developer had put that up as security as well for the job. Okay, and the builder went out backwards as well. A lot of damage because of this. Okay, so as I said, misleading and deceptive conduct where the certification was actually never in doubt. So this last point here, this was made the difference between what they were talking about at the initial trial, the Supreme Court, versus what would happen at the Court of Appeal. Liability for all commercial losses, not just for the rectification, was what they were pursuing, and that's what ended up being approved in favour of the appellant. So they awarded $3.4 million against the engineers. Engineers don't often get sued for doing things. So this is actually out there. This is actually one of these cases that people take note of. This one here. So and it's not because they did do bad engineering. They could have sat around in court and argued over the minutiae of actually what this design did, how did it affect the neighbouring property, was it, all the rest of it. But it really hinged on the fact that they certified that their design complied with the NCC. The site next door was damaged, so basically it was defective. And it was really that simple. And as I said before, leave to the High Court was refused. Now, just a few other little things to add to that. So, if anyone's actually ever heard of this mob, ACE before, Australian Consulting Engineers, and Dr. Anthony Hasham, he's got form. Okay, anyone heard of the Top Place builders in New South Wales? whose former director is now a fugitive in Lebanon, still hasn't come back. Right? ACE was his engineers. Okay. The building commissioner, David Chandler, particularly they had lots of run-ins with Toplos. So he knew all about ACE, well, particularly Tony Hasham. Mascot Towers, another development in Sydney. The problem with Mascot Towers was they said that the adjoining development, when it was being built, basement works, that caused all the problems with Mascot Towers. Who was the engineer for the adjoining development that caused the problems? Our friends at ACE again. So the building commissioner was all over this. And this was actually, ACE, Tony Hasham, was actually the first and only time that the building commissioner has actually referred an individual engineer to Engineers Australia for investigation. And they did gloriously nothing about it. And again, that also contributed to, I guess, New South Wales' push to bring out that practice standard for engineers before, because I think the building commissioner was fairly disgusted, very disappointed with how Engineers Australia engages or regulates or tries to control or keep the standard of the profession up. So we said, well, we'll just go our own way, we don't really care. So there's not a lot of love lost between New South Wales Building Commissioner and Engineers Australia. As of December 2022, you can look up this on the ASIC records. Again, public document, if you search on the right things, it all pops up. All the entities related to ACE were liquidated December 2022. So they're completely gone. But our friend, Dr. Anthony Hasham, he's still out there, still registered. Engineers Australia is still taking his fees. So now if that had happened within the current Victorian system, with all the hoops you've got to jump through here financially and all the other things to pursue, you'd be looking to drive Ubers for the rest of your life, I think. That'll be the sort of thing happening there. Yeah, quick question there?
Was he the director of the company?
Yeah, yeah, he was the main man. Look, probably a nice guy. And look, got to remember a lot of these things. There, but for the grace of God, could probably go a lot of us, okay? But you need to know what the rules are and you need to play within the rules, and if you don't think you can quite meet it or do the right thing, you've got to stop. You've just got to stop. So the point of this is to say that these changes, certainly the changes in New South Wales and they're in similar forms flowing through in Victoria, they're all rolling out and it's all around us. And we'll get on to professional engineering registration later on. I've got recent form with that as of yesterday. We can talk about that. I'm sure I'd be very surprised if many of you in the room are not at the moment engaged with the whole professional engineering registration scheme here in Victoria as well. So we might have some war stories to share there also. Is there anyone still waiting for their dinner? Just me? Well, mine will probably be in now. I might actually stop. I might stop now. And I've got a second case and a few other slides at the end of that. So.